Hello everybody, welcome to today's session. Today we're going to talk about Chapter 10, Unfair Labor Practices and Contract Enforcement. This is a very important chapter again because as managers and as union representatives and as labor relations leaders, we want all of our employment practice to be fair, to be equitable, and to be obviously enforced on a regular basis. The chapter outline includes interference with employees' right to organize, discrimination against union members, protected concerted activities, and we'll define what concerted activities basically means, duty to bargain in good faith, rights and prohibited conduct during the term of a contract. Number 6, the authority of the National Labor Relations Board. Number 7, public sector unfair labor practice and contract enforcement. And finally, individual rights within unions. So these are interesting topics that we all need to be aware of. Let's start with employer unfair labor practices. So the National Labor Relations Act basically lists certain employer activities that are considered to be unfair. For example, domination or interference with the formation or administration of a labor union, discrimination against union members for their union membership, discrimination against an employee for pursuing the rights under the Act, and refusal to bargain collectively with representatives of its employees. And finally, interference with, restraint, or even coercion of employees' rights. All of these are considered to be unfair according to the National Labor Relations Act for, obviously, workers in the United States and for managers who are operating in the United States under a bargaining agreement. So organizing activities that are protected under the National Labor Relations Act could include solicitation and distribution discussions, union button or insignias, bulletin boards and meeting halls, as well as email solicitation issues. So you and your employees should become aware of this, especially if you are a manager. You must be very careful not to violate any of these rules and policies. There are certain activities during an election that constitute violation of the law as well. They could include campaign propaganda and misrepresentation, threats and loss of benefits to employees, promise or grant of benefits, interrogation and polling of employees, as well as surveillance and certain poll activities within the organization that are considered to be somewhat formal. One rule that provides an employer who entertains a good faith reasonable doubt that the employees support the incumbent union may actually request an election, withdraw recognition or refuse to bargain with that union, as well as conduct an informal poll of employees. Again, this is related to informal polling of employees, not necessarily a formal polling of employees. So a violation of the act occurs when an employer encourages or even discourages membership in any kind of labor organization by the hiring or tenure practices or by using membership as a term or condition of employment. So usually discrimination occurs when a union member is treated differently from a non-union worker simply because he or she is involved in a union activity or activities. In the definition of concerted activities, basically any kind of legitimate action that is taken by all the employees to further their common but not individual interest, things like wages, the hours that they work, and overall working conditions in the organization. So to establish concerted activity, first of all, the issue involved must be work-related. The goal should be to further a group interest and a specific remedy or result is sought. And finally, the act itself must not be unlawful or improper. So we as managers and labor relation representatives have a duty to bargain in good faith. So labor organizations are obliged to bargain in good faith. First of all, they must have an open mind in meeting and conferring with the employer or the managers. Second, they must sign an agreement that both parties have agreed upon. And sometimes you're going to have strikes. So a strike is any type of concerted activity that is protected under the National Labor Relations Act if it is called for economic reasons. So that's what we call an economic strike, or to protest unfair labor practices, otherwise known as unfair labor practices strike. There are 4 different types of illegal strikes that you should be aware of as managers. There is what we call sit-down strike, where people just sit there and not allow customers or employees to get their work done. There's wildcat strike, there's partial strike, and there's Sickout strike. So let's talk about a couple of these. So the partial strike is basically when you're off and on. One day you go to work, one day you don't. You're trying to force the employer to change its rule or giving them an idea of what the strike might cost them. So what is wildcat strike? A wildcat strike action is a strike action that is undertaken by unionized workers without union leadership's authorization, without their support, without their approval. So this is sometimes termed as an unofficial industrial action, otherwise known as wildcat strike. A Sickout strike is an organized absence from the work by employees on the pretext of sickness. This is done to avoid the legal problems or anti-strike clauses that would be invoked in the case of a formal strike. Unlawful ends that make a strike illegal could include jurisdictional strike, feather bedding strike, and recognitional strike. In the United States, a jurisdictional strike is a concerted refusal to work undertaken by a union to assert its members' right to a particular job assignment and to protest the assignment of disputed work to members of another union or to unorganized workers. Feather bedding is the practice of hiring more workers than are needed to perform a given job or to adopt work procedures which appear somewhat pointless, complex, and time-consuming simply to employ additional workers. As we talked about before, sometimes people call this make work. So the term make work is sometimes used as a synonym for feather bedding. A recognition strike is an industrial strike that is implemented in order to force a particular employer or industry to recognize a trade union as the legitimate collective bargaining agent for a company's workers. So we call that a recognition strike. Weingarten rule is a rule developed from the case decision holding that a union employee may request the presence of a union official during questioning by management in a disciplinary situation. So again, in this case, union members do have the right to basically ask one of the labor union representatives to come and be during the disciplinary discussion between the employee and the manager. So in other words, a third person from the union is representing the employee to document and to be a witness for him or her. Keep in mind that unions restraining or coercing employees could be illegal. So actions that violate the Taft-Hartley Amendment to the National Labor Relations Act could include, number 1, physical assault or threat of violence. Number 2, threat of economic reprisals. Mass picketing that restrain lawful passage to the workplace. Causing or attempting to cause an employer to discriminate against certain employees. And finally, discriminating provisions in collective bargaining agreements. Let us talk about the authority of the National Labor Relations Board. Generally speaking, these unfair labor practice charges do come to the National Labor Relations Board through procedures that are very similar to the election petition. However, if a party disagrees with the National Labor Relations Board decision, they can appeal to a federal court to take a look at the decision that was made and to see whether they agree or disagree with the final decision that was rendered by the NLRB. Unfair labor practice in the public sector, again, can be very similar to the private sector. So the Federal Labor Relations Authority, otherwise known as the FLRA, administers usually, and they reinforce as well, the Federal Labor Relations Act. So unfair labor practices are usually defined similar to those in the private sector. Unions and government agencies are subject to unfair labor practices, and unions tend to file about 95% of labor practice charges. Federal Labor Relations Authority usually undertakes intervention techniques to assist in resolving the disputes when numerous charges are filed by the same parties, when both parties agree to the intervention process, when both parties are committed to resolving their disputes, and when charges concern institutional and relational issues or relationship issues. Number 5 would be when experiences of both parties suggest that intervention might be very, very useful to both parties. And finally, number 6, when the central office of the authority provides support for such interventions. The National Labor Relations Board can seek a federal injunction using many different criteria. For example, one of them would be union organizing campaign interference. Second would be subcontracting work to outside employers. Third would be withdrawing recognition of a union, undermining or denigrating the members of a union's bargaining team, granting exclusive representation to a minority union, or successor employer who refuses to recognize and bargain in good faith. Other criteria could include bad faith conduct during negotiations, picketing, violence, strike or picketing notice or waiting period violations, employer refusal to allow protected activities on private property, when there's retaliation to the National Labor Relations Board processes, closing down of operations during litigation, and even union coercion to achieve unlawful object. Let us closely look at some of the tips from this chapter for both union relation representatives and for management. So let's look at some tips from the experts with regards to union most common unfair labor practices. First of all, interfering with employee rights under Section 7 of the law. In states where unions can negotiate union shop provisions, employees must become a union member or at least pay a lawful fee representing the cost of being represented. Unions can seek the employee's suspension, discharge, or other punishment for not being a union member, but not if the employee has paid or offered to pay the applicable fees. Union officials have to be very careful to respect the employee's rights not to be a union member. Also, discriminating against an employee for not engaging in union activities could be unfair labor practices. A union has to fairly represent all of the employees that are covered by a collective bargaining agreement in the grievance and arbitration procedures. Union officials must be very, very diligent in investigating and pursuing employees' rights, especially for non-union employees, to avoid a charge of failing in that duty. If the grievance is not worth pursuing, make sure that fact is documented in that a union member's similar grievance was treated the same way. Again, in this case, we want to make sure that we're not treating two different individuals differently, because that would be considered discrimination. So with regards to management, what are some of the most common unfair labor practices and how can they avoid those unfair labor practices? Discriminating against a union sympathizer, organizer, or even officer as regards to discipline, especially termination, could be an unfair labor practice. So as managers, you can avoid this practice by either not touching those persons for violation of work rules or being very cautious in enforcing violations of work rules by these individuals. That is, making absolutely certain that the violation in similar treatment for non-union violation is well documented before taking action. Also, another violation could be refusal to bargain or surface bargain intentionally or inadvertently, such as in unilaterally implementing a drug and alcohol policy. As managers, you can avoid this by scheduling sufficient numbers of negotiation sessions, by being prepared and willing to make and to listen to proposals, by making some movement on at least some of the issues, and by not making a public announcement either before bargaining commences or during the process that a specific solution or action is the company's position. With respect to the inadvertent stuff, make sure that human resources and legal department are working together in the implementation of any new or major changes to the current policies or benefits to ensue no unintentional unilateral charges in terms or conditions of employment. So you, along with the human resource department and the legal department or the lawyers, should be working together with the labor relations representatives before you bring any official changes on the work procedures or to the contract of employment. Another violation would be interference with employees in the exercise of their rights. As managers, you should avoid soliciting information, spying, crossing over the line, and organizing campaigns. Make sure that thorough supervisory training is repeated regularly and supported by inadequately staffed and respected labor relations departments. Also make certain that labor relations department is available for immediate assistance when they are needed. So be fair to all your employees and do not commit any acts that would be considered unfair by the employees, by labor union representatives, or by the law in general. So implement the law, enforce the law, and as always, be ethical toward all your employees, whether they are union members or non-union members. Good luck.